धन्यवाद अध्यक्ष महोदय। जिस तरीके से आज इस सदन में ये बिल लाया गया है, उस बिल पर मुझे मेरे पार्टी की तरफ से बोलने का अवसर दिया, इसलिए मैं मेरे नेता राहुल गांधी जी का धन्यवाद करना चाहता हूं। अध्यक्ष महोदय, क्योंकि ये विषय ट्रांसजेंडर से जुड़ा हुआ है और उनकी जो ज़रूरतें हैं उस पर ना बात करते हुए उनके, क्योंकि आज देश का संविधान सभी को समानता का अधिकार देता है, उसके बावजूद इस बिल में समानता के बजाय भेदभाव को बढ़ावा देने का काम इस बिल में दिख रहा है और उनकी स्वतंत्रता के ऊपर नियंत्रण रखने का तरीका इस बिल में दिख रहा है। तो मेरी आपसे विनती रहेगी कि किसी भी समाज की प्रगति इस बात से मापी जाती है कि वो अपने सबसे कमज़ोर और हाशिए पर खड़े लोगों के साथ कैसा व्यवहार करता है। यह बिल उस कसौटी पर खरा नहीं उतरते दिख रहा है, क्योंकि डॉक्टर बाबा साहब अम्बेडकर ने हमें सबको समान अधिकार दिया है, तो उनको भी, ट्रांसजेंडरों को भी आज समान अधिकार मिलना चाहिए। उस विषय पर बात न करते हुए, क्योंकि आपने देखा होगा न्यायमूर्ति के.एस. राधाकृष्णन ने संविधान के अनुच्छेद 14, 15 और 16 की लिंग निरपेक्ष व्याख्या करते हुए यह निर्धारित किया है कि ट्रांसजेंडर व्यक्तियों के खिलाफ उनकी पहचान को मान्यता न देने के कारण होने वाला भेदभाव उनके समानता के मौलिक अधिकार और कानून के समक्ष समानता का उल्लंघन है। जिस तरीके से मैं इस बिल के विभिन्न प्रावधानों की ओर सदन का ध्यान आकर्षित करना चाहता हूं। सेक्शन 2 में ट्रांसजेंडर की परिभाषा को बदल दिया गया है। नई परिभाषा में ट्रांसजेंडर की व्यक्ति को मुख्यतः बायोलॉजिकल और मेडिकल आधार पर सीमित कर दिया गया है और स्पष्ट रूप से कहा गया है कि सेल्फ प्रिविलेज आइडेंटिटी और सेक्सुअल ओरिएंटेशन इसमें शामिल नहीं होंगे। ये इस तरीके से उन पर अन्याय है। इसका मतलब यह है कि व्यक्ति की अपनी पहचान को यह बिल मान्यता नहीं देता और LGBTQ समुदाय को इस कानून के दायरे में से बाहर कर देता है, जबकि नौते जौहर मामले में सेक्सुअल ओरिएंटेशन को मौलिक अधिकार के रूप में मान्यता दी गई है। तो आप कोर्ट का भी अवमानना कर रहे हैं। इसलिए मेरी आपसे विनती रहेगी आपके माध्यम से सरकार को कि आज समाज में रहते हुए ट्रांसजेंडर व्यक्ति ने साथ भेदभाव और मानक का पालन नहीं होता है। रोजगार उनका मुख्य विषय है। रोजगार में अपन इस बिल में कहीं पे भी उनके लिए उपलब्धता नहीं दिखाई गई है कि रोजगार के लिए उनके क्या होने वाला है। हमारे समाज में आप भी ट्रांसजेंडर को हर घर नहीं मिलते हैं, क्योंकि कहीं ना कहीं उनके लिए एक भेदभाव की भावना है। और मैडम अभी 2 मिनट 3 मिनट भी नहीं हुए हैं, 7 मिनट मेरा समय है। दे दो। हमारे समाज में आज भी उनको एक अलग नज़रिए से देखा जाता है। तो समाज में उनको कैसे सम्मिलित किया जाए, कैसे एक साथ लाया जाए, जाकि उनको भी उनके अधिकार पता रहे। आज उनको घर नहीं मिलते हैं, उस पर कहीं नहीं है कि उनके लिए घरों की व्यवस्था कैसी की जाए। आज उनके रोजगार के लिए क्या कर रहे हैं, उस पर बात करना चाहिए। तो उनको हम अलग कैसे दिखाया जा रहा है, इस तरीके से इस बिल में दिखाया जा रहा है। हमें उनको अपने साथ लेना है, ना कि उनको अलग दिखाना है। आज जिस तरीके से उनके नाम का अगर उल्लेख होता है तो मजाक बनते हो, तो वो चीज़ों पर रोकथाम होना चाहिए, वो इस बिल में होना चाहिए। वो चीज़ें कुछ भी इस बिल में दिखाई नहीं दे रही है। ट्रांसजेंडर को भी जीने का अधिकार है, क्योंकि वो भी इंसान है। यहाँ जानवरों के लिए कायदे हैं, जानवरों के सुरक्षा के लिए कायदे हैं, तो ट्रांसजेंडर के लिए कायदे होना चाहिए। उनको भी जीने का अधिकार मिलना चाहिए, ये इस बिल में लाना चाहिए। आपके माध्यम से मैं सरकार को दरख्वास्त करना चाहता हूँ कि उन्हें भी इंसान के जैसा मौका मिलना चाहिए और उनको भी इंसान समझना चाहिए। धन्यवाद।
Thank you, Madam Chairperson. I stand here today to oppose the Transgender Persons Protection of Rights Amendment Bill 2026 as a representative of the Congress Party, the party committed to justice, dignity and constitutional morality. Honorable Parliamentary Affairs Minister and Minister for Social Justice has said the bill is very important. But when they are saying the bill is important, how come this bill is coming to the Parliament without due consultation from the transgender persons and other stakeholders? This itself shows the careless attitude of the government, how the bill is unimportant to them as the people the bill represent. The government is not willing to listen to the transgender people. At the Congress, but the Congress party the leader of opposition, Rahul Gandhi ji, Ms. Priyanka Gandhi ji, and we listen to the transgender people concerned, and we deeply concerned about the issues they are raising. We would like to stand by them on record. We fully support their sentiment, support their emotions. We deeply understand what they are going through, how their life will be changing after this bill. Let us be very clear. This bill is not a reform. This bill is a regression. It takes away what the Constitution and the Supreme Court of India have already guaranteed. This is not just a legal issue. This is about real people, real lives, and the quite daily struggle of citizens who are only asking to be seen, to be recognized, and to live with dignity. Honorable Madam Chairman, in the landmark judgment of the Supreme Court, famously known as NALSA, it was recognized that gender identity is a matter of self-determination, deeply personal, deeply human. It's affirmed that dignity, bodily autonomy, and identity are protected under Articles 14, 15, 19, and 21. But what does this bill do? It deletes the right of self-determination. It tells citizens, you are not who you say you are until the state approves you. Honorable Madam Chairman, identity is not a certificate. Dignity is not subject to verification. For most of us in this house, identity have been never comes under question. We have never had to stand before an authority or a medical board or a district collector or a magistrate to prove who we are. But for a transgender person, even existence becomes a process of scrutiny. This bill deepens that injustice. This bill introduces medical board and multi-layer process for a person to be legally recognized as themselves. Nobody can be recognized as transgender person without a physical examination of the medical board and then a certificate from the district collector or magistrate. In doing so, it fundamentally alters the relationship between the citizen and the state from one of rights to one of permission. I must ask the government, why are we making an already difficult process even harder? Many transgender persons have already spoken about the immense barriers they face in securing the simple ID card. By adding more bureaucratic hurdles, we are not protecting them. We are exhausting them into invisibility. The 2011 census recorded 4.88 lakh transgender persons in India, a number widely acknowledged to be a serious undercount. Independent estimates suggest the real population runs into several millions. Behind this number are lives marked by rejection, by families that turn away, by classrooms that exclude, and by workplaces that shut doors. For many, the struggle is not for privilege, but for survival. Yes, this bill narrows the definition of transgender persons, excluding trans men, several gender diverse identities that do not fit into rigid categories. Why this selective recognition? Why this erasure? A constitutional democracy cannot decide which identities are legitimate and which are not. Equality before law cannot be conditional. Honorable Madam Chairperson, if the government claims this bill is for the welfare of the community, the record tells a different story. The average annual allocation for transgender welfare has been minimal relative to the scale of need, and a significant portion of those funds has remained unspent. When the state fails to deliver even basic welfare, by what logic does it seek greater control over identity? This is not governance. This is exclusion by design. Madam Chairperson, state like mine, Tamil Nadu, was the first one who set up a transgender board. I would like to give the due credit to the then Honorable Chief Minister, Mr. Kalanga. But it was not easy for the Tamil Nadu government. There is a lot of social stigma. The people are alienated. To sensitize the bureaucracy, to sensitize the people, so many processes has been gone through. Years has been spent. But now we are in a better position to support our transgender persons. But this regressive will take away the rights of the states, which has spent decades to sensitize their own people and their bureaucracy. This bill goes further. It introduced provisions that criminalized so-called forcing someone to present as transgender. These provisions are vague and dangerous and open to misuse. I will explain. I agree that no one should force anyone to present as transgender. But you just see, it will be misused. We give a lot of authority to police, lot of authority to many authorities. It will be risk of misused. The risk targeting families, community networks, and civil society organizations, the very spaces that often provide the only support a transgender person has. Tomorrow, you and me, irrespective of the place we are sitting, whether from the treasury bench or the opposition, we chose to support some transgender person based on their wish to support their cause. You and me can be criminalized. Is this a law we want to brought into this parliament? We need to think. Further, the bill mandates reporting of individual undergoing gender affirmation procedure to the state. In the Puttaswamy judgment, the Supreme Court affirmed that privacy, bodily integrity, and decisional autonomy are fundamental rights. This bill violates those principles. Honorable Madam Chairperson, imagine a young person already facing a stigma, now forced to fear that their most personal choices will be reported, recorded, and judged. This is not protection. This is an intrusion. What kind of democracy are we building if citizens might fear the state for simply existing in their own skin? Thousands of transgender persons have already obtained legal identity under the existing law. They have built lives, found jobs, pursued education, and begun to live with a sense of dignity that was long denied. The bill threatens to pull the ground beneath their feet. It tells them that the identity they fought for, the life they built, can be taken away by a change in procedure. Equality concerning is the complete absence of meaningful consultation. Laws affecting a marginalized community cannot be framed without their voices. If we do not listen to them now, when will we? This is not a democracy. This is a monologue of power, the identity and the trademark of Narendra Modi government. At a time when related constitutional questions are under judicial consideration, pushing such amendments without deliberation raises serious institutional concerns. Honorable Madam Chairperson, this is not just about a law. This is about whether we stand with dignity or put it on trial. You cannot ask a citizen to prove their identity in order to deserve dignity. Dignity is guaranteed by the Constitution, not granted by the state. History will judge us not by the law we pass, but by the lives we protect. Let us not be remembered as a parliament that rolled back rights. Let us be remembered as one that stood for equality, dignity, and justice for all. At the very least, the bill must be referred to the Standing Committee for detailed and inclusive consultation with the transgender community and all stakeholders. So I urge the government to withdraw the bill and send it to Standing Committee. Thank you.
Dhanyavad, Sabhapati Mahodaya. I want to thank my party, the Indian National Congress, for giving me an opportunity to speak on such a sensitive issue. I just want to start. Perhaps the most famous example is of Lord Vishnu transforming into Mohini, the women version. We have heard the stories of Samudra Manthan, how Lord Vishnu, in the form of Mohini, distracted the Asuras. We have heard the story of how Mohini tricked Brahmasura, the demon, to destroy himself. We have heard the story of how Lord Vishnu, in the form of Mohini, formed the union with Lord Shiva. We have also heard the story of how Arjuna as Brihanala, as a female dancer. We have also heard the story of King Ila, who married Buddha. We have also heard the story of Arjuna and Nag Kanya Ulupi, who united together and produced a child called Arvan. And just not to die single, Vishnuji again took the form of Mohini to get married. I want to narrate one important issue in this country, the important situation in this country. In the state of Tamil Nadu itself, The Kuthawandawar temple, I don't know if my Tamilian friends, if I've got it right or not, in Vilupuram district has built a temple for Aravan, who was a transgender. People all over the country do visit, even from abroad, even from Japan, people do visit this transgender, the temple created for a transgender. Honorable Speaker, Sir, Speaker Madam, I rise today to speak on a matter that is not merely legislative, but deeply constitutional, moral, and civilizational. The bill before this House seeks to amend the Transgender Person Protection of Rights Act 2019. At first glance, the government presents this amendment as an administrative correction, but when we read the provisions carefully, it becomes evident that the bill risks rolling back the hard-won constitutional rights of one of the most marginalized communities of our country, the transgender community. Let me state clearly, this debate is not about just ideology. It is about the Constitution of India and the dignity of human beings. Honorable Chairperson, Madam, in National Legal Services Authority versus Union of India, popularly known as the Nalsa judgment, the Honorable Supreme Court delivered a historic verdict stating that the court held that the transgender person must be recognized as a third gender and enjoy full constitutional protection under Articles 14, 19, and 21. Most importantly, the court recognized the right to self-identification of gender and held that the gender identity is an intrinsic part of human dignity and personal liberty. The court explicitly stated that no person should be forced to undergo medical tests or procedures to prove their gender identity. Yet, this amendment bill now proposes a system where identity must effectively be validated through medical authorities and administrative certification. I ask the government respectfully, are we legislating against the spirit of our own Supreme Court? Time and again, the government circumvents the Supreme Court's decisions. Sometimes even contempt of order, contempt of court has been committed. Honorable Chairperson, Madam, the Constitution does not grant dignity through a certificate. The Constitution recognizes dignity because a person exists. Article 14 speaks of equality before the law. Article 19 guarantees freedom of expression. Article 21 protects life and personal liberty. In Nalsa judgment, the Supreme Court interpreted these provisions to include the freedom to express one's gender identity. Gender identity, the court said, I quote, open quote, an innate perception of one's gender, close quote. By narrowing the definition of transgender persons, and placing the identity under bureaucratic verification, this amendment risks transforming a constitutional right into administrative privilege. Honorable Chairperson, Madam, India has historically been a civilization that recognizes diversity. Across the world, courts and democracies are increasingly recognizing gender identity as a matter of human rights and personal autonomy. Countries such as Argentina, Malta, Ireland, Denmark have enacted self-identification laws where gender recognition is based on person's declaration rather than medical verification. The Yogya Karta principles, widely recognized in international human rights law, affirm that gender identity is a part of right to dignity, privacy, and self-determination. India, through the Nalsa judgment, only 5 minutes have been up. I think my party has guaranteed me more time. Kindly just let me cover the important points, madam. Though through the Nalsa judgment, was once again the leader of Global South in recognizing transgender rights. Today, through this amendment, we risk moving backwards. The transgender community in India suffered centuries of discrimination, whether it is in the sector of education, health, employment, housing, dignity. The Honorable Supreme Court acknowledged this history and recognized transgender persons as socially and educationally backward, recommending affirmative action for them. The purpose of the 2019 Act was to remove barriers, but instead of removing barriers, this amendment risks creating new ones. As per 2011 census, only 4.9 lakh transgender community were recognized, but that was underreported. I want to ask a fundamental question. If the state begins to decide who qualifies as a legitimate identity, where does it stop? Tomorrow the state will decide who is legitimately religious, who is legitimately tribal, who is legitimately belonging to a particular caste. Identity cannot be certified by a state. Identity is a part of human existence. I just want to make one Supreme Court judgment. In the Jain Kaushik case, the Supreme Court established that expert committee should be established for regarding the harassment of trans people. the Supreme Court established that expert committee should have been established. Without establishing the expert committee, this bill should not have been introduced. What is the malice for introducing it? That needs to be clarified by the government. Therefore, the opposition is not against reform. We are not against strengthening the penalties for crime against transgender persons. The fact is that we want a stronger law. Do not dilute the principle of self-identification. Ensure the administrative process facilitate identity recognition and not police it. Consult transgender communities, the stakeholders in this, and the civil society before passing such amendments, and uphold the spirit of the Constitution and the landmark NASA judgment. Thank you, Chair.
Honourable Speaker, Madam, thank you for the opportunity. I rise today not merely to oppose this Transgender Persons Protection of Rights Amendment Bill 2026, but to fundamentally challenge the intent and the direction and the consequences of this legislation. This bill, which the government present as a reform, is in reality a retreat from constitutional morality, from judicial guidance, and from the hard-fought rights of one of the most marginalized communities in our country. Let us be absolutely clear at the outset: the transgender community in India has endured centuries of exclusions, stigma, and violence. Any law that claims to protect them must be expansive, inclusive, and rooted in dignity. Honourable Speaker, Madam, the most alarming feature of this bill is a complete removal of the definition of the transgender person as it is existed in the 2019 Act. While the Parent Act defines a transgender person as a person whose gender does not match with the gender assigned at birth, the proposed bill states that it will not include persons with a different sexual orientation and self-perceived sexual identities. The Act includes a person with socio-cultural identity as a Kinnar, Hijra, Aravani, or Jagata, and a person with variations at birth in characteristics as a primary sexual characteristic, external genital, chromosomes, or hormones from the narrative standard of male or female body. But the bill quite unfairly removes a trans man or trans woman, irrespective of whether such a person has undergone sex reassignment surgery, hormone therapy, or laser therapy, or such other therapy. It has also removed the gender queer people from its ambit. Under the Parent Act, the transgender person may apply to the district collector for issuing a certificate of identity as a transgender person. But the bill adds that the district collector will issue the certificates after examining the recommendation of the designated medical board. The board will be headed by a chief medical officer or a deputy chief medical officer. The district collector may take assistance of other medical experts. Madam, the transgender and the queer gender is all about feelings and emotions. Transgender and queer gender is all about feelings and emotions. The child notices after changes within him or within her, then realize that she or he is different from others. That is inner feelings which makes him or her to set out on journey towards self-identification. How can a medical board diagnose feelings and emotion of the persons? This amendment bill exposes this government inadequate, insensitive understanding of the transgender's mind. This bill is looking for physically and psychologically signs of transgenders, while the issue is all about inner feelings and emotions, which medical degree teaches these doctors to identify feelings, madam. Also, the district collector is the revenue head of the whole district and will hardly have time to refer the cases to medical board and then follow it up on the medical side. Doctor to are in short supply in this country. Because of this bill, transgender people will wait in queue for months and even years, waiting for the turn to be examined and declared as a transgender. Madam, the change in the gender, the Act provides that revised certificate of the identify may be obtained. One minute. where a transgender person undergoes surgery to change the gender. The bill instead mandates a person to obtain a revised certificate. The bill adds that the concerned medical institution must furnish the information regarding the gender change surgery to the district collector. Madam, this bill not only against the human being, the honorable, honorable members, I request this honorable house, this the very critical juncture we are in, because this bill is that much of against the human being. The decision we are making in this house will shape the lives of countless individuals. We cannot afford to get this wrong. I urge the government to withdraw the bill or at least refer it to the Parliament Standing Committee for detailed examination. Let there be consultation with the stockholders. Let there be a reconsideration of the definition. Let us align this law with the constitutional principle and judicial proceedings. One minute. இந்த தேசத்துல நாம் மிகப்பெரிய கடவுளாக நினைக்கின்ற சிவபெருமானை இன்றைக்கு அர்த்தநாரியாக நாம் வணங்குகின்ற சிவபெருமானை மெடிக்கல் போர்டுக்கும் கலெக்டரேட் ஆபீஸுக்கு வாசலில் நின்று சர்டிபிகேட்டை கொண்டு வாங்கல் என்று சொல்லுகின்ற இந்த மோசமான சூழ்நிலையை அர்த்தநாரீஸ்வரர் கண்டிப்பாக மிகப்பெரிய தண்டனையை இந்த அரசாங்கத்துக்கு தரப்போகிறார். நன்றி.
धन्यवाद अध्यक्ष महोदय. ट्रांसजेंडर व्यक्ती संशोधन विधेयक 2026 तृतीयपंथी व्यक्ती संरक्षण दुरुस्ती विधेयक 2026 नुकतेच लोकसभेत मांडण्यात आले आहेत. त्याआधी तृतीयपंथी व्यक्ती हक्काचे संरक्षण कायदा अधिनियम 2019 लागू होता, पण त्यात आमूलाग्र बदल करून पाहणारे हे दुरुस्ती विधेयक 12 मार्च रोजी केंद्रीय सामाजिक न्याय आणि सक्षमीकरण मंत्री वीरेंद्र कुमार यांनी मांडले. दुरुस्ती विधेयकामुळे कोणते महत्त्वाचे बदल होणार आहेत हे पाहण्याची अतिशय गरज आहे. अध्यक्ष महोदय, तृतीयपंथीयांसाठी निराळा कायदा का हवा हा समाजातील उपेक्षित वर्ग असून त्यातील सामाजिक आणि शैक्षणिक मागासलेपण सर्वोच्च न्यायालयाने देखील अधोरेखित केलेले आहे. निरंतर सामूहिक संघर्षातून ट्रान्सजेंडर समुदायाने आपले हक्क अधिकार मिळवले आहेत. मागील दशकात प्रामुख्याने कायदेशीर सुधारणा आणि संरक्षण मिळवून घेण्यात समुदायाला यश आले आहे. इतर सर्व व्यक्तीप्रमाणे ट्रान्सजेंडर व्यक्तींना सुद्धा प्रतिष्ठेने जगण्याचे स्वातंत्र्य, कायद्यापुढे समानता, न्याय आणि हक्क, लैंगिक समानता, अभिव्यक्ती व गोपनीयतेचे स्वातंत्र्य असल्याची पुनरावृत्ती 2019च्या कायद्यात करण्यात आली. परंतु लोकसभेत हे जे 2026चा आता दुरुस्ती विधेयक मांडण्यात येत आहे त्यावर या ट्रान्सजेंडर व्यक्ती स्वातंत्र्यावर घाला घालणारे हे निश्चित ठरेल असं मला वाटते. प्रस्तावित विधेयक दुरुस्तीत जी मूळ 2019चे अधिनियमित सुचवलेले बदल आहेत ते मुख्यतः 3 घटकांशी संबंधित आहे. पहिला घटक ट्रान्सजेंडर व्यक्तीच्या व्याख्येशी निगडीत आहे. ट्रान्सजेंडर व्यक्तीची व्याख्या मूळ कायद्याने व्यापक असून ती स्वओळख सिद्धांताला अनुसरून आहे. म्हणजेच व्यक्ती जन्माधारित दिलेला लिंगभाव ओळखीशी संलग्न नसल्यामुळे वेगळा लिंगभाव ओळखीशी जुळते आणि स्वतःची ओळख ट्रान्सजेंडर समजते अशा सर्व व्यक्तींचा समावेश या व्याख्येत होतो. परंतु दुरुस्ती विधेयकात स्वओळखीचा सिद्धांत पूर्णपणे वगळून ट्रान्सजेंडर व्यक्तींची व्याख्या संकुचित करते. अध्यक्ष महोदय, दुरुस्ती विधेयकामध्ये विशिष्ट सामाजिक, सांस्कृतिक, सामाजिक व अन्य घटक आहेत, पण विधेयक किन्नर, हिजरा, अवर्णी, जोगता या द्विलिंगी व्यक्ती व जन्मजात लैंगिक गुणांमध्ये विसंगती आणणाऱ्या व्यक्ती ज्यांचा लिंगभाव बदल जबरदस्तीने करण्यात आला. अध्यक्ष महोदय, ठीक आहे, ही
कंप्लीट कर लीजिए.
हे जे दुरुस्ती विधेयक आहे अध्यक्ष महोदय, हे विधेयक तृतीयपंथीयांच्या जे व्यक्ती स्वातंत्र्य आहे त्या व्यक्ती स्वातंत्र्यावर घाला घालणार आहे। यात त्यांची जी ओळख आहे ही ओळख ही सरकार ठरवणार आहे, पण त्यामुळे त्यांचं जे व्यक्ती स्वातंत्र्य आहे त्यांची जी गोपनीयता आहे ही याच्यावर घाला घालणार आहे। म्हणून अध्यक्ष महोदय, ह्या ज्या ओळखपत्र यांना घ्यावं लागेल त्याला डॉक्टर आणि जिल्हाधिकाऱ्यांचे प्रमाणपत्र सुद्धा आवश्यक आहे। म्हणून हे विधेयक वापस घ्यावं आणि यात त्या लोकांचे काहीतरी विचार त्यामध्ये समाविष्ट करून हे विधेयक एकतर संयुक्त समितीकडे पाठवावं नाहीतर वापस घ्यावं ही आपल्या माध्यमातून विनंती करतो आणि जो त्यांना घटनेने अधिकार दिलेला आहे तो त्यांचा बाधित ठेवावा ही या निमित्तानं मी सरकारला विनंती करतो। अध्यक्ष महोदय, धन्यवाद।